told that this was supposed to be visual by now.
Okay, thank you. We'll look into it. Thank you.
So the three areas we were major areas for improvement were the culture, the independence of the processes, and the repercussions on reporting. And Mr. Baker did a good outline from Deschamps on the culture, information on culture, and I'm going to follow up on another major area, which is the independent of processes. Except where sexual harassment rises to the level of criminal conduct, sexual harassment and sexual assault are treated as distinct and unrelated conduct. In the ERA's review, this strict dichotomy is misplaced and risks allowing some improper sexual conduct to go unpunished, particularly low-level sexual assaults. Moreover, the consultations raise a number of serious concerns with respect to whether the procedures currently in place are appropriate and effective. So because sexual assault and sexual harassment are treated separately, I will first start on how sexual harassment is dealt with, and then on my next intervention, I will go on to the processes for sexual assault. Although, as it was said earlier, they shouldn't necessarily be treated separately, but at the moment they are. So under the current practices related to sexual harassment, the practices and procedures for receiving, investigating, and adjudicating a complaint of sexual harassment are set out in a number of different policy documents within the CAF. As noted, DAOD 512.0 regulates 4 different types of harassment: personal harassment, abuse of power, sexual harassment, and racism. While the DAOD establishes the broad parameters of the policy, including delegation of authority to certain individuals to receive and investigate adjudicate complaints of harassment, more detailed instructions are provided in harassment and prevention and resolution guidelines, which I'll refer to as the guidelines. These guidelines are intended to provide procedural guidance in support of the harassment prevention and resolution policy. They are issued under the authority of the CDS and have the same compulsory force as DAOD 512-0. Both DAOD 512-0 and the guidelines flow directly from and are consistent with Treasury Board of Canada's Secretariat policy on the prevention and resolution of harassment in the workplace. As set out in DAOD 512.0 and the guidelines, CEOs and other more senior officers may be assigned the responsibility to adjudicate harassment complaints, and in such circumstances are referred to as ROs. ROs have decision-making authority under the DAOD and the guidelines. They receive specific instructions from the CDS to discharge their duties. Guidance is also provided to harassment advisors, which I'll refer to as HAs, whose role includes ROs with respect to processing a complaint of harassment. HAs are designated by COs and will generally be members of a unit who have either volunteered or be requested to serve in this role. The Harassment Advisor Reference Manual identifies 2 broad approaches to resolving harassment complaints. 1, alternative dispute resolution, ADR, which is encouraged, and 2, administrative investigation. Generally speaking, complainants are strongly encouraged to pursue ADR, either through informal ADR techniques used by those in the chain of command or within the assistance of a third-party mediator, before laying a formal complaint and requesting an administrative investigation. In either case, the Harassment Advisor Manual establishes that one of the guiding principles for the RO is to attempt to resolve the problem at the lowest possible level utilizing ADR techniques. When harassment has occurred and/or harassment complaint has been submitted, D&D employees and CAF members are encouraged to resolve harassment issues at the most appropriate, lowest possible level through alternative dispute resolution techniques. The focus on low-level resolution and ADR is also reiterated in either case, the harassment advisor manual establishes that one of the guiding principles for the RO is to attempt to resolve the problem at the lowest level. When the focus on this low-level resolution and ADR is also reiterated in the RO guide. Given these procedural requirements, before a harassment complaint is fully resolved, a harassment victim may be required to go through 3 separate stages. The first stage, ADR, takes place after the victim reports the improper conduct, but before a formal complaint is lodged. The second stage, the administrative investigation, is initiated once a complaint is filed. And the third stage, a grievance, occurs if a party seeks to challenge the RO's decision on the complaint. With respect to the first stage, although it is not mandatory, the CAF strongly encourages its members to start by using so-called self-help techniques, whereby the concerned individual should first speak directly to the instigator of the unwelcome conduct. If the immediate supervisor cannot help, or if the supervisor is a party to the incident, the victim may turn to a higher level supervisor to seek his or her intervention. This approach is part of the CAF's open door policy. If recourse to the chain of command does not produce adequate results, or if it is not appropriate, the member may be offered formal ADR with the help of a third-party mediator. If none of these techniques is successful or appropriate, the victim may lay a formal complaint, which leads to the second stage, an administrative investigation. This is generally initiated by a written complaint and triggers certain procedural obligations, such as that the complainant has the right to receive information about the complaint. A workplace relation advisor, a WRA, can also be assigned to the complainant. The WRA provides information about the investigation process, but cannot provide advice on the merits of the complaint. For moral and additional administrative support, both the complainant and the respondent can also receive the help of an assistant. As with HAS and WRAs, assistants are members who have volunteered or have been requested to take on that role. Once a written complaint is received, a situational assessment is conducted. The guidelines foresee that the investigation process is seldom terminated at this stage. However, there may be exceptional circumstances where the RO is completely satisfied that he or she has all the facts. In such rare circumstances, the RO will decide, based on the situational assessment, whether the criteria provided in DAOD 5012-0 are met or not. If he or she is not satisfied, harassment investigation will be conducted by a harassment investigator, an HI. An HI is either a member who has been certified as an investigator through CAF training or a civilian certified to conduct investigations. Also, if it is found that the facts warrant the continuation of the investigation process, the complainant will again be invited to use ADR. If it is determined that an HI must be appointed, terms of reference, TOR, circumscribing the mandate of the HI are drafted, and the file will be assigned to the HI. After completing the investigation, the HI must first draft a report which does not contain any recommendations. The RO reviews the draft report for conformity with the TOR. Once the RO is satisfied that the draft report is consistent with the TOR, the RO forwards it both to the complainant and to the respondent. The RO must ensure that procedural fairness is respected. The RO is then in a position to make a decision as to whether or not administrative action will be taken and of what kind. In the case of a harassment complaint that is found to be substantiated, the RO can impose remedial measures, which range from counseling to a written warning on the perpetrator's record, or in the most severe cases, counseling and probation and release from the CAF. The guidelines provide that if either party is not satisfied with the decision of the RO, he or she can grieve the decision. Although the grievance process is not used exclusively for harassment complaints, for a harassment complaint, it is the third and final stage. The grievance is submitted to an initial authority, who is usually the CO of the complainant. Upon receipt of the grievance, the CO must first determine if he or she is in a position to offer redress. If the CO has this authority and has no conflict of interest, he or she will make the initial decision on the grievance. If he or she is not in a position to adjudicate, the grievance will be forwarded to an officer who has the appropriate authority. Principles of procedural fairness must be followed, including disclosure to the respondent. If the griever or the respondent remains unsatisfied with the decision of the initial authority, he or she can ask the final authority, the CDS, to review the grievance decision. The CDS may ask the Military Grievance External Review Committee, the MGERC, to review the matter and present recommendations. The MGERC is an independent body, and it does not have authority to issue a final and binding decision, but only to make recommendations to the CDS. In addition to the multiplicity of policy documents that apply across the CAF, more explicit or specific orders may also be issued by the COs of the Naval, Land, and Air Forces, which apply to the members in the unit. Within each formation or unit, additional orders may be made which may reiterate or in some cases expand upon the words of the policy. As a consequence, just as a subordinate member must obey the order of his or her superior unless it is manifestly illegal, in practice, members must abide by the lowest level instrument, the CO's standing orders, which he or she is asked to recognize in writing upon joining the unit. For
Stand
example,
by, Mr. Bagnall.
When this committee finally gets its video, after I think it's been several hours now, will that icon up there in the corner that has a red line through it be eliminated so that we know we're on? How will we know when we finally get there? I can't hear you with them.
Mask because you're coughing without a mask, and I want to make sure.
Okay,
I'm
it
safe.
says public with conference, but it
Yeah,
never
so not. Yeah.
it never said, it doesn't say with video, it just says public. I don't know if it shows extra video, like it says that when we're public.
Okay, the clerk says that it's on, Madame Gallant.
It is?
Yeah?
So that isn't the signal there, that icon in the upper left-hand corner that's crossed
I
out.
think that's Larry's. Oh no, it isn't. Is it? That means that's 15 are on and 9 are off. That's what that means. Of the people.
It's working? Okay, thank you, Madam Chair, and I apologize.
Worry, Mr. Bagnall. Go ahead.
thank you. So, for example, unless it is illegal, a seaman must follow the standing orders issued by the vessel's CO without questioning whether these are consistent with the upper level policy statements in the DAOD or guidelines. The ERA notes that this is normative order is significantly different than in the civilian world. In civilian law, there is a clear hierarchy of law, which is vertical and works top down. The most fundamental law, the Constitution, takes precedent over statutes, which takes precedent over regulations, which takes precedent over policies. Every citizen may question the authority of a government policy, regulation, or law if it appears to be contrary to the Constitution. In the military, by contrast, a number of different policy instruments all have the same horizontal normative force. This can result in the inconsistent interpretation and application of CAF policies, and in practice may lead to practices that do not conform to the policies. Given this difference in the operation of rules, it is all the more important that CAF leadership is appropriately trained in the content and importance of policies on inappropriate sexual conduct in order to ensure a more consistent implementation of the policies across the organization. Not surprisingly, given the number of different stages involved in a harassment complaint and the number of steps within each stage, interviewees described the harassment complaint process as confusing and overly complex. In addition, participants raised a number of concerns which highlighted the substantive problems with the processes in place to investigate sexual harassment. First, at the lowest level of resolution, the ERA heard numerous serious criticisms about the CAF's policy of attempting to resolve sexual harassment complaints at the lowest level. The purpose of this policy appears to be to allow the resolution of minor disputes without unnecessarily escalating a complaint, which can be damaging both for the respondent and for the complainant. While this goal is laudable, the ERA found that, in fact, the policy acted as a major disincentive for complainants to come forward or to pursue a complaint. In particular, the policy fails to recognize the anxiety many complainants may feel about having to face the aggressor, and in fact, that the imbalance of power that may have given rise to inappropriate sexual conduct may still be at play in the context of low-level resolution or mediation. For example, while several resolute female interviewees said that they had been able to speak up about sexually harassing conduct and to confront the perpetrator, many more interviewees indicated that ADR techniques were not appropriate for sexual harassment cases because the victims were not comfortable taking a confrontational position, particularly when the harasser was of higher rank. Further, the vast majority of interviewees who did take the step of discussing their complaint with supervisors reported that the complaint was not taken seriously. Response from the supervisors ranged from warning the complainant about the negative consequences to their careers if they continued with the complaint, to openly disbelieving the victim. Regardless of the basis upon which the supervisors discouraged the complainant from pursuing a complaint, it is clear that the policy of lowest level resolution is a major impediment to the resolution of sexual harassment complaints and to a change in the overall culture at the CAF. Furthermore, the ERA heard that the process of attempting to resolve complaints at the lowest levels to undermine confidentiality, a key concern for most complainants. Lowest level resolution requires sharing the information with the supervisor or potentially escalating the complaint through numerous individuals up to the RO. Further, witnesses may need to be interviewed if an investigation is launched, all of which will result in a serious loss of confidentiality, as a number of members will necessarily learn both about the details of the incident and the fact that the victim has made a complaint. As a result, the interviewees indicated that they preferred not to report out of fear that their reputations would be damaged and the stigma would likely attach. Many victims were also concerned about being labeled as someone who would complain about a teammate, which could result in becoming socially ostracized. Interviewees further reported that harassment incidents are swept under the carpet by those higher up in the chain of command. The easy answer from supervisors when learning of a complaint seems to be, just get over it. Ultimately, the ERA found that despite good intentions from the policy, the pressure to settle a complaint at the lowest level functions to stifle complaints at an early stage and to intimidate complainants so that they will not pursue legitimate concerns. As a result, the actual or perceived roadblocks prevent victims from obtaining satisfactory resolution where sexual harassment has occurred and feeds distrust in the system. Furthermore, the policy of resolving complaints at the lowest level is inconsistent with CAF's zero tolerance policy. This policy is embodied in DAOD 5012-0. harassment in any form constitutes unacceptable conduct and will not be tolerated, is how it's quoted there. Because the practical effect of low-level resolution policy is that complainants are strongly discouraged from pursuing their complaints, and incidents of sexual harassment are swept under the carpet. This directly undermines the credibility of CAF's zero tolerance policy. Most participants viewed the zero tolerance policy as purely rhetorical, with little connection to the reality on the ground. In respect to the open door policy, at the same time, many interviewees reported facing difficulties resolving complaints at the lowest level. The ERA found that attempts to escalate complaints to a higher level were also largely unsuccessful. Although several COs advised the ERA that the CAF has an open door policy, many interviewees described this as an unrealistic option. Too many NCOs are seen as part of the boys club and concerned more with protecting the reputation of their unit than supporting the victim. Interviewees further reported that, groomed by NCOs, junior officers often turned a blind eye to inappropriate sexual conduct. Moreover, not only is it seriously frowned upon to skip a level in the chain of command, but there also appears to be only a small number of exceptionally open COs who would be prepared to act on a complaint of sexual harassment in a meaningful way when a complainant skips one or more levels of the chain of command. As a result, the practical reality is that when a member attempts to meet with the CO about a harassment complaint, the open door, quote, is in fact guarded by a number of persons who insist on knowing why the CO is being approached. In such circumstances, the possibility of filing a formal complaint with an HA is not a realistic option, nor is it the purported right of the complainant to convey his or her concerns directly to the CO or to someone at a higher level. Again, this creates a serious impediment to reporting and to the effective investigation and resolution of complaints. It only takes one person in the chain of command to make a complaint disappear. Indeed, an individual who can make a complaint disappear is generally seen as a problem solver and appropriately protecting his superior. So now I want to talk about challenges with using the ADR. The heavy reliance on ADR techniques in the compliance procedure also raises concerns. The RO guide suggests that ROs should consider ADR at two different points. First, the RO should consider utilizing ADR techniques early in the complaint process, before the administrative investigation is formally set in motion. Second, if this early attempt at resolution is unsuccessful and a formal complaint is filed, ADR should be utilized after the harassment investigation is concluded. While theoretically alternative dispute resolution has certain advantages, a number of critics have suggested that this approach is generally not appropriate when addressing incidents of sexual harassment. As one researcher notes, placing the responsibility to confront the harasser on the person being harassed does not work well within the rigid power relations and hierarchy of the military. Moreover, as a participant commented, the CAF's ADR service is designed to help restore harmony to the workplace, not to address the broad cultural aspects of inappropriate sexual conduct. This comment was substantiated by many comments the ERA heard from participants in the review. Indeed, it is not insignificant that although almost 15 years have passed since the adoption of DAOD 5012-0, the ERA was not provided with any examples in which ADR techniques had been successfully used for sexual harassment cases. Nonetheless, if ADR techniques are generally inappropriate in addressing sexual harassment complaints, there may be a limited number of circumstances in which a complainant prefers to address the complaint with the help of a third-party mediator.
All right, thank you. Is that, oh,
No,
sorry.
sorry.
Didn't
I
mean
just
to interrupt you, Mr. Bagnall.
had to get water to clear my throat. The essence of ADR is to offer an empowering approach to conflict resolution. In the context of sexual harassment, the principle is key because of the importance of victims of being able to exercise a degree of autonomy in the complaint process. For this reason, victims need to retain some control over the process and should, without pressure to settle, be offered ADR only as one possible course of action. And then there's a few other problems related to this process. Even when sexual harassment complaints are ultimately held to be well-founded and remedial measures were imposed, the sanctions were often perceived by interviewees as a slap on the wrist and meaningless. For example, being required to complete an online training course and being inconsistent. At the same time, as previously discussed, complainants may experience a number of negative repercussions as a result of pursuing a complaint, including impediments to career progression, stigma, and becoming socially ostracized. The dichotomy of outcomes for the victim and harasser reinforces a view of many members discussed above that CAF does not take sexual harassment complaints seriously. The ERA also heard frequently from interviewees that an unintended consequence of the posting system is that harassment complaints are not dealt with in a timely fashion by the departing CO and are left for the incoming CO to deal with when he or she is new to a unit and least capable of effectively resolving the matter. The fact that the cost of the harassment investigation is borne by the unit also appears to be a disincentive to ordering an investigation. Overall, the ERA found the complexity of policy and procedures related to sexual harassment diminishes the relative value of each one. In addition, the policies are at times inconsistent and inefficient. Reporting is not encouraged, and the higher leadership is protected from information about what is occurring on the ground. In fact, the CDS's instructions to COs indicate that ROs are unlikely to even hear about a harassment incident unless and until a written complaint is filed. Ultimately, many of those who use the formal complaint process were left scarred. One interviewee described the experience as atrocious, and a number stated that they would not do it again. Just to sum up here, add one last point on the collection of data. Finally, the ERA found that data with respect to harassment complaints, investigations, and outcomes are not recorded in a systematic way. Although several members indicated that it would be possible to simply enter the data with respect to sexual harassment complaints in logs already in use, this is not currently taking place. The harassment complaint tracking system appears unreliable for many reasons, including the lack of clear instructions as to how and when to file reports, confusion over coding systems, and the absence of any sanction where members simply fail to use the tracking system. The significant incident report SIR system appears to be more widely used, but as its name applies, only tracks the most serious incidents. Further, the ERA was warned about the unreliability of the Canadian Forces Health Information System, the CFHIS. The end result is a general absence of any means of assessing the frequency of reported incidences or how these incidences were dealt with, including whether investigations were carried out, the length of time between and when a complaint was lodged, and any resolution achieved, and the nature of the ultimate sanction. This makes it impossible for the CAF to measure the overall accountability of the chain of command in responding to harassment complaints, and this lack of accountability allows those in command to minimize or ignore complaints if they choose, and those who breach the policies on sexual harassment to do so with impunity. So there's a number of serious problems with the investigation process. And so what are the avenues for improvement to those? Some of them all, overall, the ERA found that the harassment complaint process is overly complex, emphasizes informal resolution to the detriment of victims, and impedes the CAF from formally confronting and resolving incidents of sexual harassment. As such, 3 important steps should be taken to improve the complaint process. First, as previously discussed, the complainant should be able to report complaints of sexual harassment to the CASAH, acting as an independent authority outside the CAF, and should have control over whether the complaint triggers a formal complaint process, including a possible investigation. If a victim chooses to not initiate an investigation, he or she should still have access to support and advice. If the complainant decides to commence a formal complaint process, the complaint would trigger the administrative investigation process. Second out of 3, the process should be simplified and streamlined. Formal complaints should be channeled directly into a grievance procedure before a CO acting as an adjudicator, rather than emphasizing the use of self-help techniques or requiring the complainant to pass through numerous members in the chain of command and then through the formal investigation process. This would have the advantage of making sure that incidents of sexual harassment would come to the attention of the CO as quickly as possible. The griever and the respondent would both be offered assistance to advise and support them with respect to the grievance procedures. Similar to the current practices for harassment complaints, the CO would have the option of requesting an HI to conduct a more in-depth investigation. Both parties would also have the right to submit a written statement to the CO. The respondent would be entitled to procedural fairness, including disclosure of the relevant information. And finally, the third recommendation, the policy should significantly reduce emphasis on ADR and low-level resolution of complaints. Requiring the victim to confront his or her harasser, particularly where there's an imbalance of power, will be inappropriate in most circumstances. While the CO should give the griever the option of utilizing the most appropriate ADR mechanism, it should be made clear to her or him that this is only one option and is entirely voluntary. The proposed model allows the member to have access to a simplified process, one that is reduced from 3 stages to just 1. In addition, under this model, the CO recommends better control of his or her unit and is able to intervene at a much earlier stage. So to summarize that recommendation, to simplify the harassment process by directing formal complaints to COs acting as adjudicators in a grievance and reducing the emphasis on ADR. And in my next intervention, as I said, sexual assault is dealt with differently, and I'll go over the processes and recommendations related to sexual assault in my next intervention. Thank you, Madam Chair.
All right. Thank you very much, Mr. Bagnall. Monsieur Robillard, s'il vous plaît.
Merci.
Thank you very much, Madam Chair. I would like to continue on the topic of CRC, the Intervention Center on Sexual Assault. It is giving accounts directly to its supervision. The services of the Intervention Center on Sexual Assault are available all across the country and in all theaters across the world through partners with internal and external organizations. Those services include support and recommendations for members. The services are being offered by the Professional Military Conduct Branch, DCMP, the planning and coordination activities at the strategic level, we are promoting dignity and the respect of the person. The executive director of the SRMC are under the director to ensure independence of services being offered to military members being affected by sexual misconduct. The CIIS are offering services to regular service members, cadets, rangers, and to the commanding chain. This is part of its mandate, and so this center also offers advice to the military center according to anything having to do with sexual misconduct. With regard to changing the culture, the CIIS is offering services and advice to military members. Advisors are listening without any judgment, victims, and try to understand each situation. They work together with victims and other advisors to allow victims to be able to make decisions. They recognize, respect, and work with them to better understand the needs of the individual member. They also take into consideration members' feelings, emotions, needs, worries, and their fears. They do not have any, there are not limits on phone calls in order to allow each member as much time as possible and the victim's preferred language. This is very important for Francophone victims. It ensures that they do not feel ignored. Advisors also advise victims about what the CIIS can and can't do in order to refer them to another service if need be. Also, regarding the topic at hand, we have the responsibility to focus on victims, survivors. Their health and well-being must be our priority. And this is why we must focus on recommendations to honor our commitment towards the armed forces. I will now give the floor to my colleagues, but I will come back to this very important topic later on. Thank you, Madam Chair. Thank you, Mr. Robillard.
Madam Chair, thank you very much. And I'd like to thank my colleagues for their fulsome interventions as well. We have a lot of good substance on the floor this afternoon. Madam Chair, I wanted to circle back to the Wixton report, which I had introduced earlier with respect to its executive summary. And I wanted to just circle back briefly to a comment by Air Chief Marshal Wixton in the introduction, in which he refers to two components of the work to change the culture. The first of which, of course, is that it's the right thing to do. It is morally wrong what is happening in the Canadian Forces, and as we saw in so many other forces, including the British Armed Forces. The second argument he makes is that it is not only morally the right thing to do to achieve culture, but we will, all of us who do this across jurisdictions, will achieve a better armed forces system in the process. He calls it performance enhancing. The conclusion being that anybody who engages in sexual misconduct, harassment, or worse, actually weakens the Defence Forces, weakens every member currently serving, and by reputation also past serving in the forces. So I think that was a point very much worth highlighting. Colleagues have also referred to the fact that, following up on Mr. Wernick's testimony, that there are a number of countries that are dealing with this. It's by far not Canada alone. Any country basically that has armed forces that are subject to democratic control is facing similar issues. And that's not for a moment to say as Canadians that we have to worry about this less because other countries are equally handling this unsuccessfully so far or incompletely. It's the opposite. It's just acknowledge that this is a systemic problem that has to do with the culture of masculinity that's been described by many of our witnesses across jurisdictions, across allies. And in some brief research this morning, Madam Chair, I think I spent 15 or 20 minutes looking at this issue, and I discovered that there were questions and in many cases initiatives in Sweden and Poland and Australia and New Zealand and South Africa and in the United States, in addition to the work that I described earlier with respect to DCAF, the Center for the Democratic Control of the Armed Forces in Geneva, and also NATO that had looked at this issue. So for the benefit of our analysts, who I'm very happy to see online, and I'd like to thank them through you, Madam Chair, for their tremendous work in preparing our draft reports. I think it's important to flag that this is a pan-jurisdictional issue with comparative elements and comparative opportunities. And I'd like to get back into the Wixton report in a bit more detail in the introduction, and actually highlight the fact that the Wixton report itself refers to Canada and the Canadian experience. So what we say and do will not only achieve change here, but will also very potentially and very tangibly influence the policy opportunities and opportunities for progress on the part of our allies, especially the ones that we work most closely with, including the Five Eyes. Madam Chair, the Wixton report makes the following identificatory statement with respect to the issue that we're studying. It says, for the purpose of this report, we defined inappropriate behaviors as those which breach laws, norms of behavior, or core values and standards, including sexual offenses and bullying, harassment and discrimination, that harm or risk harming individuals, teams, and operational effectiveness, and that bring or risk bringing the reputation of individuals, units, the service, or defense into disrepute. That is the definition that they've adopted. I put it to colleagues for their consideration. The report continues to say that the armed forces and civil service operate to different terms and conditions of service. However, defense people exist within a shared culture and environment. The report focuses on the armed forces, regular and reserve. However, it identifies opportunities to work better as a whole force, including the MOD civil service, wherever we can. The need to adopt a whole force approach is reinforced by the lessons of others, in particular the Canadian Armed Forces, who went through an extensive process of review in 2015. And Madam Chair, that's just to underscore the point I made a minute ago with respect to the Canadian experience actually being looked at by other forces as well. And the review that's being referenced there is the ERA that my colleague, Mr. Bagnall, just took a detailed look at in his previous intervention. The Wixton report itself then comprises three separate sections. Part 1 is an assessment of the current situation in the United Kingdom. Part 2 considers what more could be done to stop inappropriate behaviors occurring. And Part 3 makes recommendations on what more could be done to deal with inappropriate behaviors when they have happened. And a key recommendation of Part 3 is the establishment of a new defense authority responsible for cultures and inappropriate behaviors external to the single services chain of command and responsible to a defense senior responsible officer, emulating the successful models of the Canadian Armed Forces, Australian Defence Force, and United States military. And just for context, Madam Chair, this report, of course, was put out in 2019, some 2 years ago, and prior to the specific incidents that this committee is also studying. Mr. Bagnall, in his previous intervention, made reference to a very important component of the External Review Authority, or the ERA, in which is the question of data. And here, I think the British experience is also helpful to this committee for its deliberations as we go forward through the coming weeks. Under the subheading Management Information, the Chief Air Marshal says the following: to build a comprehensive picture of the behaviors and culture of any organization, it is necessary to have a single repository where all key data is collated, monitored, tracked, and analyzed. The resulting intelligence can then be used to inform the chain of command to address issues at the earliest opportunity by enabling resources to be directed to specific hotspots, situations with a high risk of victimization, for example, or to specific types of behavior. Annual statistical data and courts-martial outcomes from cases in the service justice system, the service complaints system, and surveys, as well as reports from the single services, demonstrate a significant effort to capture available information. We observe that the convergence of data and information within each service lacks depth, and that there's no coherent analysis at MOD level. Serious cases within the service justice system and the service complaints system capture broad headline data sets such as gender, age, type of offense and complaint. But this is superficial, and at present there's insufficient metadata captured to provide an appropriate level of insight, nor is there a consistent approach across minority groups. Furthermore, we do not automatically receive comprehensive data or information on cases dealt with in the civil courts. So we cannot describe the full scale of the issues within defense at the most serious level. This would require a change to primary legislation. We judge that better and more coherent data would provide actionable information for the chain of command at all levels and centrally for defense to identify where additional training, support, and intervention is most needed. And Madam Chair, I'm going to get into some of the recommendations that are being made. But just to preface the fact that, because we're mentioning the recommendations does not mean necessarily that we should accept them. In some cases, we may legislatively, by virtue of our customs, procedures, and constitutional structure, not be able to adopt them as easily. But they are here for us to consider because in my submission, they have the right level of granularity, they have the right level of specificity. They will move us forward. And with that in mind, I would like to just mention 3 recommendations that the Chief Air Marshal has put forward under management information. The first of which is that defense must improve the level of detail and metadata captured on serious, unacceptable behavior, as well as instances of lower severity to provide a single comprehensive picture of appropriate behaviors across the inappropriate behaviors, across the organization. Secondly, defense should consider amending primary legislation to require the sharing of information from the civilian justice system. And thirdly, under this rubric, defense should develop performance measures relating to inappropriate behaviors for use at Defense Board, Executive Committee, and performance and risk reviews. And Madam Chair, with this recommendation in mind, you'll recall a brief exchange that I had with Rear Admiral Patterson, where I asked her if there was an option to include gender equality championship. I think that was the way I put it at the time. Include them in performance evaluations within the Canadian Forces, and her initial reaction was absolutely yes. So there may be some ground here based on this very specific British recommendation for us to actually be able to make a recommendation in parallel in our system that would achieve culture change and progress. Madam Chair, the report also makes recommendations with respect to the use of surveys. And again, this is not for us to accept, it's for us to debate and potentially accept what we find appropriate and constructive. But the report says that defense should conduct a harassment survey in 2021, building on the Army Sexual Harassment Survey in 2018, informed by an independent advisory group. In line with recommendation 3.1, defense should consider a quote-unquote call for evidence on inappropriate behaviors in conjunction with the survey in order to provide supporting detail to the survey. And in parallel with that, defense should better coordinate and focus the bullying, harassment, and discrimination elements of continuous attitude surveys to improve understanding, reduce duplication, and streamline data analysis. Use of contemporary online survey formats should also be considered. This, Madam Chair, is a set of very tangible, very specific recommendations that go to the issue of data management. Calling the problem what it is a first step, and I think in many respects this committee has done it. Getting the data that speaks to the qualitative and quantitative aspects of the problem is equally important, and then having the opportunity to actually analyze the data at the right level with the right specificity and granularity is crucial to taking us forward. The report makes the recommendation under climate assessments, and climate in this context is not climate in the context of climate change, but it's climate with respect to the work atmosphere in climate. The report says a proactive process for assessing the command climate and behaviors is now well established across all 3 services. The Army has developed and matured a tiered process, including the completion of focus group-based analysis with units led by trained facilitators. The Naval Service conducts a similar advisory process, as do the Royal Air Force. This approach, utilizing focus groups by trained facilitators, is seen as leading practice and is utilized by other nations and organizations, including the United States military. Such data, although confidential, can be analyzed centrally and utilized as a tool to understand behavioral themes. And there, Madam Chair, you can see that the reference in this report, just in the few brief sections that I outlined, to both Canada and the United States really put us onto, in some ways, a common denominator with our allies with respect to the nature of the problem, but not only acknowledging that we have the problem, but also finding potential solutions. And these two suggestions here, vis-a-vis Canada and the US, adopted by the British report, indicate that collaboration and joint problem solving may well be worth our while. At a minimum, taking account of and reviewing the reports by leading countries in our group of allies and friends would be extremely worthwhile for this committee. The recommendations that follows from this is that climate assessments and advisory visits should be sustained and exploited across defense. And I'll finish with a recommendation on values and standards, Madam Chair, and I'll come back and subsequent interventions. Each service has established and operates a core set of values and standards. These values and standards developed over time and from extensive operational testing reflect the unique culture, ethos, and operating environments of the respective armed forces and civil defense. Values and standards for the Royal Navy, Royal Marines, Army, and Royal Air Force are well established, comprehensively communicated, and understood. The governance surrounding the Civil Service Code is less well recognized, as noted in the Sue Owen review, which observed that in some workplaces, staff are looking for a more explicit articulation of the behaviors they should expect to see. Communication of the Civil Service Code must therefore be amplified and include military line managers of civilians. And the recommendation that follows is that single service values and standards should be sustained, but communication of the Civil Service Code should be amplified. This, Madam Chair, is also relevant. Again, by page, I'm surprised at how poignant these recommendations just are, specifically with respect to the issue in Canada, also potentially involving or actually involving civilian employees of the Canadian Forces. So there really is some substance here, some fodder for deliberation, and some opportunities to achieve real and tangible progress. And I would encourage all my colleagues as we go through these experiences in other countries to take note, also our analysts, and I look forward to reactions from members of the committee. I'll leave it there for the moment. Thank you, Madam Chair.
Much. All right, where are we? Mr. Baker is up next, please.
Thanks very much, Chair. And I want to thank my colleagues for speaking to a number of the important considerations that we should take into account for this study. I think Mr. Spengeman's interventions on the Wixton report are important, and that they underline that other militaries have been trying to resolve some of the same issues that we're trying to resolve here and in this committee. And I think it's sound advice on his part, Mr. Spengeman's part, that we strongly consider the specifics of what's in that report, the Wixton report. There's probably a lot there that we could learn and consider in applying solutions to the problem of sexual misconduct here in the Canadian Armed Forces. And I thought the interventions by my other colleagues were also quite welcome. I appreciated Mr. Bagnall's comments about the processes that are followed, and there's a lot, I think, in terms of the processes that are followed that we need to learn from and clearly adjust here in Canada. I wanted to go back to an issue that I was speaking about earlier, which is around culture, and I think when I left off last time, I was talking about some of the some specific examples cited in the Deschamps report about the kinds of treatment that women are often subjected to, women who are serving in the armed forces are subjected to, and I wanted to continue on that theme in here, in particular in the Deschamps report. And I'll read from the report here, they speak to how women deal with that. They say, ultimately, many women report having to develop a thick skin and to become desensitized to a culture of sexually inappropriate conduct. LGBTQ members also report a similarly degrading environment. Notably, while the ERA heard numerous comments about the hostile environment that results from pervasive low-level harassment. Fewer participants reported instances of quid pro quo harassment. That's in which an individual feels pressured to accept unwelcome sexual conduct in exchange for some workplace benefit or to avoid some detrimental action against her. The ERA found, therefore, that members of the Canadian Armed Forces are less likely to be faced with quid pro quo harassment than they are to be affected by an overall organizational culture that conveys demeaning and negative attitudes about the role and the value of women. And I read on, perhaps not surprisingly, male and female members of the Canadian Armed Forces generally reported vastly different perceptions of the occurrence of inappropriate sexual conduct. While most male participants in the review recognize that the experiences of their female colleagues are different, many of these male interviewees did not perceive that there is a pervasive inappropriate sexual conduct in the Canadian Armed Forces. Rather, many men perceive the treatment of women in the military to be similar to what they would experience in broader Canadian society. And some felt that women, in fact, fare better in the Canadian Armed Forces than men do. Others argued that inappropriate incidents are simply inevitable as a result of the integration of women into the Canadian Armed Forces, or expressed the view that a certain degree of aggression is appropriate in the military. In particular, most men did not view sexual language as harassing and thought that attempts to, quote, police language would be, quote, ridiculous, as one male participant stated, quote, and I quote here again, or the report quotes here again, girls that come to the Army know what to expect, close quote. I mean, this is just horrendous. But I think it speaks to the specifics of some of the things that we've heard from victims, that we've heard from women, and that some of our witnesses have spoken to. I go on, while women of a higher rank seemingly do not suffer as much from the sexualized environment, the ERA found that this is largely because members appear to internalize the prevailing sexualized culture as they move up through the organization. And so whether to achieve their career goals or as a coping mechanism to adapt their own cons of the organization. So I think what's important here is that what I'm trying to underline here to our colleagues is that the tremendous amount of coping that mechanisms that are put in place by women, according to the Deschamps report and echoed by our witnesses. I'm going to leave it there, Chair.
Go ahead, Vanderbilt.
Thank you very much, Madam Chair. I have a proposed amendment. I would like to amend the motion to read that the Standing Committee on National Defence concerning its study on addressing sexual misconduct issues in the Canadian Armed Forces, including the allegations against former Chief of Defence Staff, hold on, I just lost that. Okay, hold on. Actually, Madam Chair, you know what, I may not have a motion at this time, so I'm just going to allow Mr. Baker to continue talking. Very, very sorry, Madam Chair.
Well, it's what time is it now? 2:55. Okay, so well, it's 2:55. So anyway, this meeting is suspended until further notice.
No.
Until after votes, Madam Chair,
Until after votes.
not further notice.
Thank you.